can you tell us some common myths about the rights of children with disability in education and the corresponding truths?
Okay, common myths. That kids with disabilities have to go to special schools. Wrong. Kids with disabilities should go to regular schools with everyone else. And in fact, I get into arguments with people in and outside the disability sector when I say this, but one of the reasons that we don't have enough resources in regular schools for kids with disabilities is because we're still putting them into special schools. So I think we ought to be thinking hard about that, and that's actually also my view about sheltered employment. I think we'd get more people into open employment if we didn't put as much resourcing as we do into sheltered employment. And why wouldn't kids with disabilities go to regular schools? When they grow up to become adults, they're not going to, or they oughtn't to, live in special institutions. They oughtn't to work in closed employment or special employment. They don't drive on special roads or go to special shops or swim in special swimming pools. So why wouldn't we build our society for kids to look like the one that they're going to have to live in as adults? So I think that's perhaps the key myth. Now, the Disability Discrimination Act doesn't say that kids have to go to regular schools, but the Convention on the Rights of People with Disabilities, on which the Act relies, which is an international United Nations convention, known by most people as the Disability Convention. I call it the DISCO because Australians just shorten things. And also I like the concept of calling it the DISCO because I sort of think that means that people with disabilities can go anywhere, even to the disco. So the DISCO does say that kids should be going to mainstream schools. So I suppose that's the first myth. What other myths? Does my child have to be treated in the same way as other kids at the school? Yes. Is that substantive treatment? In other words, does that mean that reasonable adjustments or reasonable accommodation have to be made to support my child so that they can participate in a class in the regular school? Yes, it does. That's what the discrimination law says.
Does the same apply to field trips and school camps?
Absolutely. So, if a kid is not properly going to school, if they're not going on the school camp or the excursion, this was one of the arguments in the Finney case, where they said, oh, well, Scarlett can't come to the school because she won't be able to go on excursions, because she won't be able to get onto the bus, which at that stage was not accessible. Scarlett, I think I said before, had spinal bifida and used a wheelchair. And her mother had made arrangements so that she could go on the excursions, but the school weren't prepared to take that into account. Now, there are going to be some issues with kids playing sport based on the nature of their disabilities. It wouldn't be a good idea, wouldn't have been a good idea when I was at school for me to be trying to play footy or cricket with all the other kids who could see. I probably would have had a crack, but that probably wouldn't have been the best result. So there have to be some compromises made, but compromises shouldn't take the form of, oh, well, he can't go on the field trip or she can't go on the school camp. The compromises should take the form of, well, of course she can go on the school camp, but these particular activities might have to be done differently. So, other myths. I want to talk a bit more about complaints and the process of conciliating complaints. Is it a requirement when I agree as a parent to the conciliation of a complaint that that agreement has to contain a confidentiality provision? No, it's not. It might be something you choose to agree to, but it's not a requirement. And this is where I actually disagree with my own organisation here, because I know in the the draft agreement that the Human Rights Commission sometimes makes available, there is a confidentiality clause. I tell people, just strike that out, cross it out. Because the problem with confidentiality clauses is, and some of you might be in this position, if you've taken a complaint all the way to the Human Rights Commission and you found a settlement, of course the Education Department or the school authority want you to have a confidentiality clause, because they don't want the rest of the group on Lee's Facebook page to know what the settlement was. And so they want to prevent you from talking about it. You don't have to agree to that. Now, the upside of that is that the word gets around as to what you've resolved. The downside, of course, might be that the school might say, well, we won't agree to this if there's a confidentiality clause. And you've got to make a judgment at the end of the day what best works for you, and that's the way that individual complaints have to be determined. When I lodged my complaints against Railcorp, I did two things which lessened the value of a confidentiality clause. The first thing that I did was, at the same time I lodged the complaint, I sent a media release to the local papers. So what I had done by doing that was put the complaint on the public record. Now, your complaints aren't about announcements on trains, I get that. Your complaints are about your kids at school. And some of those details you mightn't want in the media, and you mightn't want to be that confrontational. So all these things are strategies, right? They're not rights or wrongs. But one of the things that you do if you lodge complaints, and one of the things that a group up here might decide to do, is lodge a bunch of complaints. So you might lodge 10 or 15 complaints against the school system from different kids with disabilities. Okay? So send a media release out to the local papers saying that those complaints have been lodged, and talk about the issues in the media release in general, but don't use specific examples or name special schools. What does that do? It immediately puts the complaint on the public record. So when you get to the conciliation conference and the lawyer from the Department of Education says, oh, well, we want to put in a confidentiality clause, and you then you can say, oh, well, that's a problem, because this complaint's on the public record already, it's been in the newspaper, and if we don't provide an answer to that newspaper story, then people are out there wondering what the Department of Education has done about this. Wouldn't it be better to put out another media release saying, we've resolved this complaint, these kids are happily now going to these schools, what a great bunch of guys the Department of Education are. So you've actually cut away the rationale for confidentiality clauses. And I feel quite strongly about this. And again, I'm not saying it's right, because you've got to make your own decision about your own complaint. But it's really important for us to get systemic change to be able to share the information. And confidentiality clauses just work against that. I'm sure there are other myths that I haven't thought of, but let's get to it. Yeah.